Good morning, students. Today on Monday morning, I am interacting with all of you. Though every day seems like Sunday because of the lockdown, but still I thought that this lockdown must not make us lose the track which we were in when we were studying company law. And I thought of interacting with you with a 10 minutes video on a daily basis to teach you about various aspects of company law. First of all, we will get into the revision mode, and after that, I will even teach new topics here. So keep a track of the same. If you have got any doubts, you can text me and I will put up clarifications as soon as possible. So let's start. Today we will start with the topic company and its various characteristics and what is the procedure for formation of the company. So company, as we all know, it has been defined under section 2 subsection 20 of the Companies Act 2013. The Companies Act 2013 defines the company as a company which is incorporated under this act or any other previous company law. So this does not provide an exhaustive definition of company, rather it is called a limited definition. So for the exhaustive definition of company, or what does company actually mean, we have to see into the characteristics of company. So there are multiple characteristics of the company. I would just highlight the main characteristics here. The first characteristic of the company is that company is regarded as an incorporated association. Incorporated association, or we may say it as registered association. A company is a registered association, and any company which is existing without getting itself registered is regarded as an illegal entity. Though in case of a proprietorship firm or a partnership firm, we can even run those businesses without getting it registered, but company requires compulsory registration. Secondly, separate legal entity. This is one of the most important characteristics of the company. This says that company's identity or entity is individual and it is not related to the entity or identity of its members. It was upheld in the case of Solomon versus Solomon and Company Limited, which clearly stated that company and its members are separate from each other. So the we say identity or the existence of the company is not dependent on the existence of its members. The third important characteristic of the company is limited liability. This is one of the biggest advantage due to which people we say go for company formation of company. Limited liability means that the members' liability is limited to the extent of either shares held by them or extent of the guaranteed amount, if any, they have promised to contribute at the time of winding up of the company. This again depends on the nature of the company, but whatever the nature might be, it is the liability of the members is always said to be limited. This makes the company as an advantageous in an advantageous position, because this benefit is generally not available in case of proprietorship firms and in case of partnership firms, because their proprietor's liability or partner's liability is said to be unlimited. That means if the creditors cannot take the receive payment from the firm, then they can even make the partner or the proprietor personally responsible for repayment. But in case of companies, members are not personally responsible, only they are responsible till the extent of the unpaid value of shares or guaranteed amount, whichever the case may be. The next important characteristics of the company is that it has got perpetual succession. That means members may come, members may go, but the company goes on forever. How we say that is that even if practically all members of the company are dead, but still the company's existence will not be hurt because of that, and it is perpetually succeeded by one after the other. It is brought into existence by law. It can be only brought to end by law. That is no other process of ending a company. The next characteristics is common seal. As we know, a natural person can sign the documents by putting a signature. But in case of a company, the signature is done through the official seal of the company, that is also called the common seal, that is to be affixed in all important documents of the company. Next characteristics is capacity to sue and be sued in its own name. This is because the company is an artificial legal person. Though not born naturally but born legally, the company can file a case against anyone, any third person, or even its members in its own name. Similarly, a member or a third person can file a case against the company in its own name. It does not require any natural person to do so. Though representation will be made through natural person, but it can do so in its own name. It can hold separate property. That means the company can hold property in its own name, and again it does not require a natural person to do so. Then separation of ownership and management. The company owners are generally regarded as the shareholders of the company, but the shareholders are not the persons who manage the company. They do so only through the representative body, that is called the board of directors. And the company is professionally managed unlike other businesses which are generally managed by the owners of the business. So we say that's why separation of ownership and management is practiced in company law. Next is statutory obligation. There are multiple obligations which are put up in place for the purpose of maintaining the sanctity of this particular form of business, that's company. And this particular sanctions or this particular obligations are considered as much more than what is in case of partnership or proprietorship. So that's why small businesses generally prefer for forming a proprietorship firm or a partnership firm, whereas large businesses generally go for a company form of business organization. So this was in short about various characteristics of the company. Refer to your notes for the detailed version of this particular characteristics topic. Next, we move on quickly to what is the procedure for formation of the company. As we all know that the company can exist only when it is incorporated. So for the purpose of incorporation, there is an authority deputed by the Government of India that is known as Registrar of Companies. Registrar of Companies is region-wise allotted for various states. For the northeastern states, the Registrar office is situated in Shillong. So whenever a company needs to get itself registered, there are certain important documents which it must prepare pre-hand for the purpose of getting itself registered. First document, which is very important, is the name approval form. So name approval is required for the purpose of forming the company. For getting the name approval, the proposer must apply with the registrar of companies, proposing 3 names in order of preference, out of which the registrar will select one name as the approved name, and this name can be used for the purpose of the name of the proposed company which they are forming. And this name must not be undesirable, must not be identical or similar to the name of an existing company, and must not prohibit or is not prohibited under the Emblems Act. So that must be seen when the name is finalized. Next, after getting the name approval, there are certain other documents which are to be prepared and which are to be filed with the registrar of the companies. The first amongst this document is Memorandum of Association and Articles of Association. In the later videos, I will detail about what are the various contents of memorandum and what are the various contents of articles. For now, it's just memorandum is required and articles of association is required. The next important document is a declaration by various professionals. The professionals might be either chartered accountant, a company secretary, an ICWA, or a lawyer. This particular professional must be someone who has been engaged in the formation of the company, and the declaration must state that the company is complying with all the provisions whichever is mentioned in the company law. The next important document is an affidavit which must be given by the subscribers to the memorandum, stating that they are not involved in any offence which is prohibited under the company law for being subscriber to the memorandum. The next important document is an address of correspondence which the registrar will use temporarily for the purpose of communicating with the company in case any additional information is required from the company. The next document is the details with the address and identification of all the subscribers to the memorandum must be submitted along with the application form. The next is whoever is the first director of the company, their complete details along with the name, addresses, the director identification number, and their identity proof needs to be submitted to the company. And further, the last document is a declaration by the directors that they are not involved in any offence relating to related party transaction or similar other offence which act as a prohibition for anyone to become director in a company. After all these documents are placed in order, these documents are to be submitted to the registrar of companies along with the prescribed fees. When this document is submitted, the registrar authenticates the documents, and if everything is found in order, then the registrar will grant a certificate of incorporation. The certificate of incorporation is the conclusive evidence that the company has come into existence as a separate legal entity. And whenever this certificate of incorporation is issued, it is issued with a CIN number. CIN number is a corporate identity number. This is a unique number granted to every company, like we have got a PAN number for every income tax, we say SSC. Similarly, there is a CIN number which is there for each and every company for maintaining their unique identity. So this was in short about how we can form the company. But regarding formation of the company, there has been substantial change in the procedure in relation to the year 2019, and nowadays companies can be incorporated by going through the online portal of the Ministry of Corporate Affairs, and all this document can be uploaded there digitally, and even the name approval can be taken in the online mode. So nowadays this particular provisions of company law which we state that in regard to submission of documents to the registrar, is no more required, and that everything can be done online. So thank you all for being throughout this video, and I would be in touch with you again tomorrow with a new video. Thanks for watching, and get back to me with the feedback as well as any clarification. Thank you.